Good day. I am Yvonne Balinas, a fourth-year legal management student from San Beda University, Manila, a Filipino citizen from the Philippines. Today, I am here to discuss to you one of the most important topics in our subject, business protection laws. But first, let me give you a background about my country, the Philippines. The Philippines, or the Republic of the Philippines, is an archipelagic country in Southeast Asia. It is situated in the Western Pacific Ocean and consists of about 7,640 islands that are broadly categorized under three main geographical divisions from north to south. We have the Luzon, the Visayas, and the Mindanao. It is considered to be an emerging market and a newly industrialized country, which has an economy transitioning from agriculture to being based more on services and manufacturing. The Philippines is also a founding member of the United Nations, the World Trade Organization, the Association of Southeast Asian Nations, and the Asia-Pacific Economic Cooperation Forum and the East Asia Summit. For today, we'll learn more about the legalities of owning real and personal properties in the Philippines. So for today, we are going to answer two of the most important questions in our subject, business protection laws. First, we will answer whether the real property ownership in the Philippines should be limited to Filipino citizens only, just like what we have currently in our system, basing from our organic law, the 1987 Constitution. Second is that whether the law on protection of personal property sufficient to safeguard the rights of businesses to its ownership and property.
The first question is whether real property ownership in the Philippines should be limited to Filipino citizens only. Aliens, as a general rule, are not allowed to own real property in the Philippines. By aliens, we don't mean creatures from outer space, but persons who are citizens of other countries. The prohibition on foreigners owning Philippine lands is embodied in no less than the Philippine Constitution. This, in fact, is one of the usual reasons cited by those who want to revise or amend the Constitution, because the Constitution provides in Article 12, Section 7, that save in cases of hereditary succession, no private lands shall be transferred or conveyed except to individuals, corporations, or associations qualified to acquire or hold lands of the public domain. It is clear from this provision that private land may be transferred only to persons or entities who or which has the capacity to acquire or hold lands of the public domain. Those who are qualified to acquire or hold lands of the public domain are as follows. First is the Filipino citizens. Second is the corporations of at least 60% of the capital of which is owned by Filipinos. In other words, the Constitution explicitly prohibits non-Filipinos from acquiring or holding title of private lands. Among the exceptions are as follows. First is to transfer to an alien by way of legal succession or if the acquisition was made by a former natural-born citizen. The Constitution provides in Article 12, Section 8, that notwithstanding the provisions of Section 7 of this article, a natural-born citizen of the Philippines who has lost his Philippine citizenship may be a transferee of private lands, subject to limitations provided by law. The Supreme Court reiterated this general rule in a recent case, Borromeo versus Descalar, in GR number 159310, February 24, 2009. The court also reiterated the consistent ruling that if land is invalidly transferred to an alien who subsequently becomes a Filipino citizen or transfers it to a Filipino, the flaw in the original transaction is considered cured and the title of the transferee is rendered valid. There are other exceptions to the prohibition on aliens owning real property in the Philippines, like full ownership by foreigners of condominium units, but this shall be subject for future discussions under the ownership of land by former Filipinos. So you see, buying property in the Philippines is not always easy. In addition to the many documentary requirements, there's also the need to be cautious about seller's ownership. Unfortunately, titling of a large portion of land in the country has still not been done or has been muddled in bureaucracy and disputes. This gives way to other potential issues and false claims of ownership. When buying a property in the country, it's best to be cautious and follow all legal requirements. This will help you protect you from anomalous transactions and any ruins with the law. Real property ownership by a foreigner is limited to non-land property such as buildings or condominiums. You may own a house or building but not the land where it was built. However, foreigners may still own land under the following circumstances, like if it's an inheritance, as a corporation where you may subscribe to a domestic corporation with at least 60% Filipino ownership and purchase land under the corporation's ownership. To sum it up, the general rule is that only Filipino citizens and corporations or partnerships with at least 60% of the shares are owned by Filipinos are entitled to own or acquire land in the Philippines, subject to the following exceptions. First, acquired before the 1935 Constitution. Second, acquired by reason of succession or inheritance. Third is purchase of not more than 40% interest in the condominium project. Fourth is former natural-born Filipinos can own land in the Philippines, subject to limitations prescribed by Philippine Republic Act 8179 for residence purposes up to 1,000 square meters of urban land or 1 hectare of rural land, and Batas Pambansa 185 for business or investment purposes 5,000 square meters of urban land or 3 hectares of rural land. Last is that Filipinos who are married to aliens who retain their Filipino citizenship unless by their acts or omission they have renounced their Filipino citizenship. At this point, we now move on to the question whether the law on protection of personal property is sufficient to safeguard rights of businesses to its ownership and security. So, with the creation of security interest under the PPSA rules, parties are free to enter into any form of security arrangements over movable property as long as the security arrangement is not inconsistent with the PPSA or the PPSA rules. So, to protect the rights of the parties to transactions involving personal properties, the PPSA imposed the following. First, the PPSA rules directed the Land Registration Authority to establish the registry within 6 months from the publication of the PPSA rules. Second is the creation of a valid security interest over personal property under the Philippine law will be entirely governed by the PPSA and the PPSA rules except interest in aircraft. Third is the perfection of security interest after a security interest has been created. And fourth is the specific guidelines on private or public dispositions are set out in Section 7.09 of the PPSA rules. We can now see that the measures that they imposed, as stated above, strengthened the secured transactions legal framework in the Philippines. It also provided for the creation, perfection, determination of priority, establishment of centralized notice registry, and enforcement of security interest in personal property, tangible and intangible, except aircraft and ships. It gives direction to certain agencies on how they will deal with personal properties. Hence, PPSA really protected the rights of the parties to transact involving personal property.
So that's all for today. I hope that you learned something about our subject, business protection laws, about owning real property and personal property in the Philippines. Stay safe and God bless us.